So, ladies and gentlemen, I would like to welcome you very much here on behalf of the Europa Institute at the University of Zurich. As you know, we have a special guest here tonight for this lecture. This is Professor Johannes Chan, the former long-time Dean of the Hong Kong University Faculty of Law. He has been in Hong Kong even after he left office as a chair professor until, if I'm right, 2021. Mm-hmm. And in 2021, he left Hong Kong to go to London, as many other Hong Kongese did it in those days. You might talk to us a little bit about why you left. I assume, you considered that the situation in Hong Kong for someone like you, who has a high public profile in maintaining, supporting rule of law, and on many occasions, not as a dean, but as a legal counsel and the Queen's Counsel, defended people's movement before the court against the Hong Kong government. And we have to say, in many occasions, you won. And of course, this made you a kind of a difficult person, maybe from time to time, for the Hong Kong government. But this was all fine until, the umbrella movement came, and then, mainland in a way intervened, and things have changed. So Hong Kong today is not probably what it used to be. And we are interested to learn from you how you, judge the situation, how you see things have developed, where you came from and where we are going to now. And the Hong Kong experience is what you're going to talk to us. Very warm welcome to you, Johannes. Thank you very much for coming.
Thank you. Thank you, Andres, for the kind introduction. For a speaker, it is always an embarrassing moment when you are introduced in a way that you don't even recognize yourself. But thanks for a very kind word and the hospitality, and it's really great to see so many of you here. And this is reassuring that the issues of Hong Kong could attract so many people here. And I know a lot of you have some kind of connections with Hong Kong, and I'm glad to share with you my views of what's going on. And so what I'm trying to do in the next 15 minutes or so is to run through what has happened in Hong Kong, and coming from a constitutional law background, inevitably I'll also talk about how the court responds in all these. And being a former dependent territories of the Britain for over 150 years, as you know, Hong Kong became a special administrative region of China in 1997. And under the so-called one country, two system. And indeed, the one country, two system itself rests on a lot of assumptions there, including assumptions such as the underlying reason is a political one. Reunification of China is something which is bigger than history. Every major Chinese leaders wants to achieve that. And of course, Taiwan is very much the bigger picture in mind. And Hong Kong was intended to be a showcase, basically, for China. It is also for economic reasons. In 1984, around that time, Hong Kong is responsible for almost 80% of all the foreign income of China. And Hong Kong, in a way, would play an important role in the modernization of China, which has just come out from Cultural Revolution. The opening up of China, they really requires the international experience, the contact of Hong Kong, the system, economic success of Hong Kong in helping with the modernization and economic reform for China. So it is really a mixture of these political and economic reasons that leads to the Joint Declaration in 1984. And there's also the pragmatic reason, having just come out from Cultural Revolution where the country was completely shattered. They do not have the expertise, and which they realize they do not have the expertise to run a modern international metropolis like Hong Kong. So they need Hong Kong in a way, the management experience, the international contact, to help building the developments of Hong Kong. And under these premises, it seems, therefore, in order to complete the agreement, to at least to persuade the British to agree to the agreement of returning to Hong Kong, some human rights provisions have to be there. So fundamental rights, rules of laws, in a way, were set out in the agreement as part of the base, one can say, to achieve these political and economic missions of the world. So right from the very beginning, in a way, the Joint Declaration, or the so-called one country, two system, may have different interpretation, and one interpretation, at least amongst the leaders of China, is probably it is one country, two economic system, rather than just one country, two system, to allow a completely different system to coexist side by side. And in 1984, it is probably true to say that China needs Hong Kong more than Hong Kong needs China. Of course, 30 years down the road, the situation is completely different. Hong Kong is now responsible for 2.5% of the GDP of China only. Taiwan as a showcase, Hong Kong as a showcase for Taiwan, has completely lost its value. Taiwan won't believe that anyway. And the economic power has shifted completely. In 1984, the political power is with China. It used to be saying that China can just shut the water tap and Hong Kong will have no water supply in 7 days. We rely on food supplies from China. The political power is clearly with China. On the other hand, the economic power is one side. Hong Kong, in a way, holds a upper hand of economic power in 1984. No longer the case. And with the increased integration between China and Hong Kong over the last few years, it is now the situation Hong Kong needs China much more than China needs Hong Kong. Perhaps with the areas that Hong Kong still remain a major international financial center, as long as the RMB is not freely floating, Hong Kong is still a useful place for raising capital. And of course, there are still Hong Kong connections of international experience. But the relative position has completely changed in a way, and the asymmetrical model in the past, the asymmetry in political power is balanced to some extent by the asymmetry in economic power. Now it is all one-sided. And the entire one country, two system model, the Joint Declaration has no enforcement mechanism. It rests entirely on tolerance, goodwill, and self-restraint on the central government. Of course, you will hear the central government saying that they are always committed to the one country, two system. No one doubt about that. The question is, what do they see as one country, two system? And as I suggest earlier, their perception of one country, two system is really one country, two economic system. That's what they want. They are not envisaging that Hong Kong is growing into a political center. Hong Kong would be a place for revolutionary idea, challenging the central authorities. It is not what they want for Hong Kong. So that sets the background in a way, leading to what happened until for almost 20 years or 15 years after the changeover in 1997, Hong Kong continues to thrive economically. Hong Kong continues to enjoy a high degree of prosperity and freedom. It is a place where it is taken almost as a showcase for common law liberalism, where the rule of law, human rights, the independence of the judiciary are respected. Until the last 3 years, Hong Kong has appeared in international newspaper headline, which is not a good thing, about suppression of fundamental rights and all these things in the name of national security. So how does this change about in a way? And in the last 3 years, one question I have always encountered is is there still a future of the rule of law in Hong Kong? Is there still judicial independence in Hong Kong? That is the sort of questions that I come across all the time in the last few years. Hong Kong itself, in a way, provide an interesting case study, how a place where used to have a very strong judiciary with strong liberal values there could turn within a very short span of time into what it is today. So briefly, I try to recap this history with also a bit of focusing on how the judiciary responds to all these challenges from the central government, and then lead to some thoughts of my own. So let me see. And the background, I don't need to go into the details for one country, two system. And the Joint Declaration in 1984 seals that a high degree of autonomy, Hong Kong enjoy independent executive, legislative, and judicial power. And then these were written down in the Basic Law. And the three main pillars, in a way, is firstly is the common law system is retained. So mainland law and policy do not apply to the Hong Kong SAR except in foreign affairs and defense and central local relationships. Hong Kong SAR set up its own court of final appeal, replacing London as the court of final appeal, and it is allowed even to have a panel of very distinguished overseas judges sitting on the court of final appeal. And since 1997, the court has established a practice that there will always be one overseas judge out of the 5 judges in every single substantive appeal before the court of final appeal. And this panel of judges include even former Chief Justice of Canada, New Zealand, Australia, and of course a number of judges from the UK Supreme Court. Fundamental rights are guaranteed by the Basic Law, which also entrenched the International Covenant on Civil and Political Rights as applied to Hong Kong into domestic law. The so-called Article 39, which is of interest, it is under this article where the court developed a series of liberal jurisprudence on Hong Kong human rights in the last 20 years. Whereas later on we'll see a similar clause which exists in the national security law, does not serve the same purpose at all. So over the first 15 years, a strong and liberal court that is highly receptive to international and comparative jurisprudence. Human rights, the rule of law, and judicial independence are largely respected and flourish, despite some hiccups, which is inevitable. And part of the reasons the ideological conflicts was largely contained or sidestepped throughout these years. With one or two riders. One rider is right from the beginning, Beijing already realized the power of interpretation will tell you all about judicial independence. After all, the power of the court lies in the way they interpret the law, and who has the final say on the interpretation, who will control the situation. So during the drafting process, there's one question which have always been raised by China, is what happened if the court got this wrong? And that doesn't bother a lot of constitutional countries. You've got it wrong, court got it wrong all the time. There will always be balance between the legislature and the court. Beijing was quite concerned about that, especially if they have the power to interpret the Basic Law. So at the end, a complex system was made up saying that the power of final interpretation lies in Beijing, in the Standing Committee of the National People's Congress. Hong Kong court can interpret the Basic Law in the course of adjudication, but when it comes to the Court of Final Appeal, Court of Final Appeal has to make a judicial reference to the NPC Standing Committee for interpretation. At that time, it was said that this system was borrowed from the EU system, where country states will have to refer to the European Court of Justice on an interpretation of the EU treaties. But there are two fundamental differences. One is the ECJ is a court. The MPC Standing Committee is a political organ, and it conducts its business behind closed door. Even the agenda of the Standing Committee is national secret. And the second part, of course, in a referral from a member state to the ECJ, the parties basically move to before ECJ and argue the case. To just continue the legal proceedings with full rights to be heard. Whereas you do not know even when MPCSC is going to make a decision on what, and let alone there be any rights to be heard in that sort of situation. But nonetheless, the power of interpretation, which has been used and invoked, depending on how you see it, at least 6 times in the last 20 years. For those who support it, they said that, well, it's only 6 times. For those who are against it, 6 times is quite a lot. And then the other control is the democratic development in Hong Kong. The pace and the scale of democratization is basically determined by the MPC Standing Committee. And in 2004, it was by that time the legislature comprised of an equal number of members returned by direct elections, universal suffrage. Another half returns by an elite system called functional constituency. And this is basically a small elite groups. And as far as the chief executive is concerned, he or she is elected by an election committee that largely mirrors the composition of the functional constituency. And that has been a major source of conflict in the last 20 years. People in Hong Kong ask for a greater pace of democratizations that Hong Kong deserves. And in 2007, the MPC Standing Committee agreed to allow universal suffrage, election by universal suffrage of the chief executive. And if that is successful, then the legislature could also follow to be returned by by universal suffrage. Some people are a bit disappointed. It still took 10 years before that is reached, but at least you have a goal and you have a map plan towards it. Later, it transpired that this promise is on certain conditions, which I'll come to in a moment. But under that contrived political models, the pan-democrats in Hong Kong, in every single geographical elections, they won over 60% of all the votes. But because geographical constituency represent only 50% of all the seats there, so they remain forever in the minority groups, notwithstanding they won every single major geographical elections. And those who have the mandate but with no power, of course, are not very happy with the situation. And they are faced with only 2 choices. One choice is to go to the street. And Hong Kong has developed a culture of demonstrations on all sorts of issues, almost a weekly event. Someone will be demonstrating for some things. Hopefully, the government will hear the voice of the people, galvanizing public support outside the establishment. The alternative is to take the government to court. And someone started that in around 2020 and 2005, 2004, notably by an activist called Long Hair. And the pan-democrat found that actually is quite useful. They have quite some success relying on the basic law, suing the government. The court is quite liberal, and the court lays down all kinds of decisions. And the government, although it's not too bad, the government is prepared to listen to the court. They are prepared to comply with the court order. So as a result of the success, it encouraged also, on the one hand, you have the street politics of public demonstration. At the same time, you have the litigations, constitutional litigation flourish in our court. As time passes, the difficulty is that more and more political issues are brought to the court when they could not be resolved at the political channel, leads to the politicization of the court. And time and again, successive Chief Justice warned the public the role of the court is to decide the law. The court is not a social engineering for social reform, nor could the court decide political issues. But as time passes, the expectation has grown, and increasingly the court is being criticized or even attacked according to whether the result complies with one's political aspiration. And as a result, the court is attacked left, right, and center, whatever they decide, in an increasingly polarized environment. And it's this democratic deficit that leads eventually to major demonstrations when the governments, when the time is closer to 2007, 2014, and in 2007, it was promised that 10 years later, you will have direct election of the chief executive. So around 2010, people start thinking about that. And if we are going to have direct election of the chief executive, how should we go about it? And then it transpired that what Beijing's intent is you can have direct elections, but then we will decide on the candidates. So we give you the candidates, and then you decide which one to pick by universal suffrage. Of course, a lot of people thought that that is not real universal suffrage. And it resulted in a major movement called Occupy Central, indeed instigated by one of my colleagues at the Faculty of Law. And the idea is a kind of civil disobedience, occupy the major district of the financial center, and hopefully that could put pressure on the governments to conform. And my colleague at that time thought that they are going to occupy the place probably for 3 or 4 days only. It ended up they were there for 79 days and end up with a court injunction, and which is not surprising in a way. Similar sit-in in different parts of the world, including London, Melbourne, Sydney, following the Wall Street occupations. They all end up, after 2 or 3 months, they all end up with an injunction by the court ordering the dispersal. So in that sense, Hong Kong is not that different. After all, they blocked the major highway for 2.5 months, and eventually some taxi driver association and minibus driver association took the matter to court and saying that you are affecting our livelihood. Enough is enough. And initially, the government responds with some brutal police action, and that has caused more people to join the protester. But after 79 days, nothing happened. The police, after that, they stay away. They adopt a policy of non-interference, but also no discussion, no communication, and try to wear you out and see how long you can stay there. And just now we have been talking, before the talk, talking about what happened in Tiananmen Square in 1989. And before the crackdown, it is a lively place, a lively civic place where all kinds of activities were taking place. To some extent, that echoes what happened in 2014 in Hong Kong as well. The place was very tidy, surprisingly, with so many people having their camps there. All kinds of talks, seminars are going on, all kinds of interesting political discussions were carried out. And after 19 days, and when the governments refused to budge, refused to talk, refused to negotiate, and with a court injunction, it dispersed. And obviously, particularly the young people were a bit frustrated. They are expecting something. And after 79 days, they found that the effort is in vain. They become frustrated, and that started some of the younger group feels that the old Democrats their way of fighting for democracy doesn't work. They keep talking, put pressure on the government. It won't work. They resort to more radical social movements. And from that point onward, some people even suggest that we need self-determination. And that, in a way, scare Beijing when you start talking about self-determination. After that, there was a period of calm and restoration of stability, where the government could have made use of that period really to resolve the dispute on democratization and the democratic development. But instead, the government's response by aggressive prosecution of all the activists, and then they try to disqualify the pan-Democrat candidates who tried to take part in the election. And some of the young people thought that after the unsuccessful umbrella movement, maybe they should take part in the political campaign, try to get themselves into the legislature. And a few of them did get elected. And very soon, the governments tried to disqualify them. And during that period, two prominent developments. One is there were ideological attack on the role of the judiciary, given that the judiciary is playing increasingly a central role in this development. And there were attack about the doctrine of separation of power. And the second is the direct interference with the judicial process. And between 2017 to 2021, various criticism has been made against the judicial separation of power. And you can see one of the legislator, Hong Kong delegates to the Standing Committee of NPC, criticized the court of arbitrarily creating new law, adopt an elitist attitude in discharging its duties, and excessively inflate its power and its role. And the Director of National Security Office said that the judiciary should highly manifest the national will and national interest, or else it will lose the legal premises of the authorization. Almost a threat to the judiciary, mind your own business in a way. And the chief executive said that the court has been misinterpreting the position. Hong Kong never have separation of power. There's only divisions of labors only. And interestingly, from 2020 onward, Hong Kong's secondary school textbook have all the references to separation of power deleted from the textbook, as if it never exists. At the same time, just now I mentioned some of the youngsters resort to participate in political elections. And these are two of them who emerged after the failure of the Occupy Central movement. And these two young people, they got elected to the legislature. They have to take office and they have to take the oath of office. And during taking the oath, they put up a banner, as you can see, Hong Kong is not China. And then they took their oath in such a way, they changed certain words so that it becomes highly insulting. And as a result, the governments decide to take out disqualification action against them on the basis that they have declined or neglect to take the oath, so they would be prevented from entering office. And in the meantime, while the disqualification process was taken out, the NPC Standing Committee decided to interpret Article 104 of the Basic Law, which said that when assuming office, certain public offices, you have to take the oath of allegiance. This is basically just a provision in the constitutions providing for the framework for the oath and declarations to be taken. But and while the case was ongoing, the disqualification process was ongoing, submissions of the parties have been made, the court adjourned its decisions over the weekend so that the court could think through it and write the judgment. Over the weekend, the NPC Standing Committee decided to call an emergency urgent meeting, which starts on Saturday, run through Sunday, and on Sunday night, they managed to adopt an interpretation of Article 105 of the Basic Law, which published on Monday, just in time to make sure the court cannot deliver its judgment without referring to its interpretation. And that interpretation basically decides everything that the court has to decide in the disqualification procedure, including what is the effect if they fail to take the oath. Would it allow the presidents to allow them to retake the oath, or it would lead to automatic mandatory removal? So, and not only has the NPCSC predetermine the issues before the court, it also extends the requirement of the oath. Early on, we've seen that Article 104 actually talk about when assuming office, you have to take the oath. Now, it has been interpreted and extended to include that you have to take the oath before you are eligible to run for election of public offices. So from an oath requirement, from a formality requirement, it is now turned into an eligibility requirement. If whether you are eligible, and you have to swear allegiance to the basic law and the government, and if you are, and with that process, every single candidate now have to swear the oath, and in swearing the oath, the returning officer will have to satisfy that you are sincere about your oath. And how to determine whether you're sincere about the oath, they go back to all sorts of evidence there, including what you have posted on your Facebook, what you have said in public, etc., etc. And so as a result, it becomes a very arbitrary process. And for those who have already been in place, the governments now point to what you have been doing is contrary to the oath, and therefore you will be disqualified. And as a result of that, the oath becomes a useful weapon to get rid of the oppositions and the dissents. And immediately after that, at least 6 elected legislators were disqualified from taking office. Later, another 13 candidates were disqualified from running. And seeing that it is quite powerful, this method has been resort to far more frequently afterwards, especially after 2019, extensive use of the oath to disqualify oppositions. And earlier on, I also said some of the youngsters refer to a more radical proposition. And radical, in fact, is all in relative terms. They have done nothing apart from talking. And they advocate self-determination. And one of the youngest group, or younger people's group, they form a Hong Kong National Party. The name itself is a bit provocative already. And they advocate, at some point, they should discuss self-determination. They are not really advocating self-determination, but they advocate that this is an issue which the Hong Kong legislature or Hong Kong community should discuss at some point in the future. And that was banned by the Hong Kong government under the Then Society Ordinance because it is unlawful in advocating Hong Kong independence. So self-determination suddenly becomes a red line that you cannot cross. And it is only not the red line. The Hong Kong National Party's chairperson was Andy Chan, and he was invited by the Foreign Correspondents Club to give a lecture. And the Foreign Correspondents Club comprised of all the journalists, both local and international. They say it's just common for us journalists to hear from the horse mouth. So if he's advocating, we just want to hear what he actually say. And it's a sort of luncheon talk. And by holding that, the Foreign Correspondents Club was condemned by the Hong Kong government for providing a forum for these separationists to publicize their view. And Victor Mallet, the vice chairman, later, a few months later, his work visa was not renewed by the Hong Kong government. Fast forward and then to 2019, which is the triggering effect of what happens now. There was a bad murder case. Hong Kong person who was alleged to murder his girlfriend in Taiwan returned to Hong Kong. The community was furious about that. And the government said there's nothing we can do because there's no extradition arrangement between Taiwan and Hong Kong, which is true. And as a result, the Hong Kong government let's plug the gap there, and so enact an extradition bill. And fine if you proceed with some extradition arrangement between Hong Kong and Taiwan, but the government make use of that opportunity also to introduce an extradition arrangement between Hong Kong and mainland China. That got on the nerves of a lot of people, including business people who have first-hand experience of how the criminal justice system works on the mainland China, and now they can be extradited from Hong Kong back to China. So that bill has received strong objections across the community, and in 2 major demonstrations, reportedly attracting 1 million and 2 million turnout, and opposing the bill. The government would not budge, the government insists to proceed. Eventually, the legislative process was halted when a group of protesters stormed into the electrical building, and that was stopped. And that marks a dramatic change in the history of Hong Kong. Before that, all along, all public demonstrations are conducted largely peacefully. From that point onward, more radical confrontations took place. Police responded with brutal actions, and that escalated the violence on both sides. And in the following few months, Hong Kong entered into a phase of social disorder, and there were violence happens everywhere. And also followed by a period of crackdown of oppositions. So that forms the basis. But even within that, it lasts for probably a few months. There's nothing to suggest that Hong Kong government would not be able to contain the opposition or the riot at that time. And there are sufficient weapons or statutes in Hong Kong, including all the criminal law on riot, unlawful assembly, which the government has used and indeed has been using to confront the situation. Nonetheless, the National People's Congress decided to enact the National Security Law. It was enacted without any proper consultation or without any consultation of the people of Hong Kong. And the people of Hong Kong read the bill, read the law for the first time when it was published, which came into effect at the same time. On the face of it, it said that it is to restore order, law and order, and only a small minority of the people will be affected. But once you look at the law itself, firstly, it introduced broad and sweeping national security offences. Second, it exerts comprehensive jurisdiction over Hong Kong, while Hong Kong enjoys a high degree of autonomy. This is now for the first time China has an official presence in policy making in Hong Kong. Senior China officials now sit on committee as a formal member overseeing policy governing national security in Hong Kong. And also, it contains various powers to curb and restrict judicial power and discretions, in a way reflecting the continuous skepticism about judicial power and judicial independence. And it introduced four major offences: secession, subversion, terrorist act, and colluding with foreign forces. All drafted in rather vague language and in a style which is typical of the mainland drafting style, which is quite different from the more specific common law style of drafting. A lot of policy statement there. And for secession and subversion, it doesn't have to be with force, so the offence could be committed merely by words. And instead of, up to now, not many cases, defendants were charged with offense of secession or subversion. Mostly they are charged with incitement to subvert or incitement to secession. And incitement is encouragement, and incitement usually is done by words. So you can be guilty of incitement by words to commit an offense, which is also constituted by word. So it's a verbal offense to commit another verbal offense. And one can see the line is very vague. The scope is pretty uncertain. There are also revival of old law, archaic colonial law, which have not been used for over a century, for half a century, and they were invoked and has been used more frequently, notably the offense of seditious publications. And for comprehensive jurisdiction, I mentioned they set up a committee for safeguarding national security. A high-level Chinese official now formally sit on the committee. The interesting thing is that while this committee has wide power concerning everything about implementation of national security, this body is confidential, its proceeding is not known, there's no transparency, its decision is not subject to court review. And there were special units setting up within the police force, within the Department of Justice, so secretive that even the Director of Public Prosecution is not involved in prosecution of national security offense, which eventually led to the resignation of the Director of Public Prosecution. And in terms of the judiciary, there were policy directives requiring the judiciary to uphold the constitutional duty of protecting national security, which has been interpreted as meaning, one, no offense under the national security law could be challenged for being unconstitutional. And second, any decisions made by the National Security Committee is not subject to judicial review. There was one challenge when the National Security Committee made a decision suggesting that a foreign British lawyers should not be allowed to come to Hong Kong, and it was challenged that that decision has nothing to do with national security as such, and the court's answer basically that's outside the jurisdiction of the court. We cannot intervene with anything decided by this committee. There were provisions to oust the jurisdictions of the court, and particularly under the Article 56, under certain circumstances, a person could be removed out of Hong Kong and to be tried in mainland when it involves complex foreign elements there, whatever that means, or when Hong Kong is unable to handle or to enforce the national security law. Again, unclear what that means. And under these circumstances, a person could actually be taken out of Hong Kong and tried in the mainland according to mainland law. So after that, after the enactment of the national security law, it follows with a period of ruthless and aggressive prosecution. Over 10,000 people were arrested, primarily under Public Order Ordinance and the Crimes Ordinance for the civil arrest in 2019. Another 300 has been prosecuted under national security law. And so far, for those cases which have been completed under national security law, the conviction rate is 100%. No one single defendant managed to escape convictions. And for some of the cases where the prosecutions fail, at least at the lower court, they pursue an aggressive appeal, or even if the sentence is too lenient, they appeal all the way to the highest court. And coupled with something mentioned in a moment, there were extensive pretrial detention, and only designated judges are allowed to try national security cases. And with the vague law there, the red line is everywhere. It is unclear when you will cross the line. And once you cross the line, the danger is that you could be detained before trial, and some of the defendants who were detained under the national security law has been detained for over 3 years, and the trial is still ongoing. So up to a point, it encouraged arbitrary arrest and prosecution, and it doesn't really matter at the end of the day if the prosecution is successful or not. You will be detained for 2 years, 3 years. That serves the purpose, and that serves sufficient chilling purpose and deterrent purpose. Free speech and press, immediately after that, they first go after the media, and media organizations were raided. They have their assets frozen, management arrest, eventually forced to be closed down. And one of the major newspapers in Hong Kong, Apple Daily, the proprietor is a successful businessman, Jimmy Lai, and he is very supportive of all the pro-democratic movement. He participates in a lot of demonstrations. He provided funding for some of these demonstrations and the protesters, and he was immediately go after. He was arrested, and he has been in prison, apart from a short period of a few days where he got his freedom back. He has been detained since he was arrested until now. His trial is still ongoing, and a lot of people believe that the outcome of the trial has already been determined. The question is how many years he has to serve, and given he's already in his late 70s. And as a result of the frozen, when all the access of Apple Daily was frozen, it eventually led to the close down of the newspaper. And another online media, Stand News, very influential online newspapers, all the senior editors were charged with seditious publications. And the only allegation is they published about 80 articles on the newspaper, which is critical of the government. And and it was alleged that they have a particular political line, and so they choose only articles which is critical against the government. One is newspaper always have a political stance. There's nothing new about that. And at the same time, the newspaper is able to show that they publish other newspaper, other articles with other views as well. Nonetheless, it seems that the government is prepared to go along, and the case has dragged on for almost 2 years now. The trial has just been completed. And the editor defends himself well in court, giving evidence, almost teaching the court what is editorial freedom, how do editors choose newspaper, and so on, which is quite enjoying in a way, although in a sad situation. And the judgment was supposed to be delivered, and then it has been adjourned twice. And the latest is the court is now further adjourned the case to August, at the end of August this year, before judgments will be delivered. By that time, some of them would have been detained for almost 3 years by then. And apart from online medias and other major media organizations who have been closed, others have to exercise great self-censorships. And one of the well-established Chinese newspaper, Ming Pao, they have a cartoonist which have been working with Ming Pao for over 20 years, a quite respected political cartoonist who draw cartoons making fun of the government. And just a couple of months ago, Ming Pao announced that they have to terminate the contract with the cartoonist, apparently for reasons that it is not convenient to disclose. Press freedom aside, there's crackdown of civil society, and apart from a large number of arrests, prosecution of political activists and dissidents, indeed many of these arrests were related to their public statement, political stance, and other political activities. And people were also charged for raising funds. At least 14 people were arrested for financial activities, including crowdfunding campaign to support pro-democracy demonstrators, or even to support the legal costs for the defense. There was a fund which was set up, known as the 612 Fund, because it's established on the 12th of June, and it has gathered a lot of money from the public by donations, and they try to fund all these protesters who were arrested. They fund their legal defense, and all the administrators of the 612 Fund are now been arrested, and the fund has to dissolve itself. And in the name of national security, pure speech, peaceful assembly without violence were punished. Another notable case is some leading Democrats in Hong Kong. They participate in the peaceful demonstrations on the 18th of August, and 8 of them were asked to stand at the front of the demonstration holding a banner. And for that, they were charged with organizing an unauthorized assembly, and it was conceded by the prosecution that the demonstration was peaceful all along. Nonetheless, they were convicted of organizing an unauthorized assembly and participating in an unauthorized assembly. The organizing charge was set aside by the Court of Appeal, saying that merely holding a banner at the front of a demonstration, that is not sufficient evidence of organizing. But the participation charge was upheld, and they were given custodial sentence from somewhat between 8 months to 18 months just for participating in an entirely peaceful demonstrations, and including some of the most well-respected Democrats in Hong Kong, people like Martin Lee, Margaret Ng. They were all convicted, although some of them received a suspended sentence. And over 80 civic groups, professional unions, labor unions, student unions, indeed, ironically, all the student unions in all universities in Hong Kong have disbanded themselves. And human rights organizations, including like Amnesty International, has to move out of Hong Kong and relocate elsewhere. And most of the prominent social commentators have left Hong Kong and operate overseas. The drastic law also leads to miscarriage of justice in a way. Many defendants plead guilty after a long period of detention, not because they thought they were guilty, but hopefully that could cut short their sentence by pleading guilty. It may or may not work, and because there are minimum sentence for NSL offense, and the court, in one case, adopt a starting point of 5 years of imprisonment, and then after considering mitigation factors, the court reduced it to 4 years, and then the prosecution appeal, and on appeal to the Court of Final Appeal, the Court of Final Appeal agreed that minimum sentence is minimum sentence. No matter what mitigating circumstances, you still have to serve the minimum. So on the one hand, there's mandatory minimum sentence. It is unclear whether mandatory minimum sentence will affect remission in prison. The general practice in the past is if you behave well in prison, you can get 1/3 of your sentence remitted, and you can be released after serving 2/3 of the sentence. It is unclear whether this would be affected, but in the latest Safeguarding National Security Ordinance, this has been restricted, and the governments or the correctional service would not allow remissions unless he is satisfied that you will not commit further national security offense upon release, which is difficult to prove after you have been serving your criminal sentence in prison for 3 or 4 years. On what basis can they say that by releasing you, you will be a threat to national security? And one of the defendants was caught immediately. He would have reached the 2/3 and got released 2 days before the new law was passed, and he now has to serve another 1.5 years. And it affects not only criminal process or public demonstration. National security law is now everywhere. Mandatory requirement of introducing national security education from kindergarten. And I'm at a loss. How could you teach kindergarten children national security? And all the way to universities. And recently, Chinese University of Hong Kong was criticized for not including a clause on national security in their tendering agreement. And it's a tendering agreement for construction work. Why would anyone include a clause on protecting national security? And they were criticized by the Audit Commission. There were, and the uncertain law, and even secondary students, school students, they skipped the hoisting of national flag in schools. They were suspended from schools as a result. And certain arts academy, they have invited the wrong guests, and they were criticized, and the funding institution threatened to withdraw funding. And at the same time, the police set up a hotline for reporting any act of committing or suspected national security offenses. And surprise, surprise, since it's setting up by March this year, the police said that they have received over 700,000 complaints about national security offenses. Can't imagine Hong Kong could still be Hong Kong if there are so many. And in the 4 years period, if you have 700,000 complaints of violation of national security, that is one complaint every 3 minutes. And which is quite a lot on a 24-hour basis. But then it established the sort of culture which is not unfamiliar in China. Everyone is watching everyone, so that you will always be under surveillance. And one of the things we've heard from people from Hong Kong, or my friends from Hong Kong, is they feel relief once they're outside Hong Kong. At least they can talk freely with their friends, whereas in Hong Kong, everyone tried to talk about weather, and try to avoid sensitive issues. And it applies also to my colleagues in universities. You never know when students will be reporting you or in a public lecture. And there were cases where in the various universities, professors were criticized. And even one of my colleagues in the arts faculty, when she appeared as an expert witness in the first case of national security, and then he was criticized for appearing as an expert witness for the defendant, which is weird in a way. And as if that were not enough, there were also major reform of the legislature. And in 2019, after the civil unrest in Hong Kong, there was a district elections at the local level, and the district elections, partly as a result of the civil unrest and the extradition bills, the Pan-Democrat have a landslide victory, winning and controlling 18 out of 19 districts. And the government was quite worried about that, and later they introduced the requirement of oath, that everyone will have to take the oath, and if you don't take the oath, you will be disqualified. If you take the oath and if you found you fail to live up with the oath, you will also be disqualified, but at the same time, you will be visited with legal proceedings. So as a result of that, it forced 260 successfully elected district board members to resign, resulting in 70% of these district boards vacant, and the governments won't bother, just leave the local authority without sufficient members there. And then they start to reform the Legislative Council. The end result of it is that while, as you see in 2004, for a long time, the universal members returned by universal suffrage represent at least 50%. Half of the legislature was returned by universal suffrage. It now is reduced from 35 to 20, and also enlarged the number from 70 to 90. The net effect is now members returned by universal suffrage represent about 12% from 50%. But at the same time, they substantially increased an election committee, which represent almost half of the members. And these election committees are all appointed members, basically, or from various pro-government results. And the governments require now patriotism is the criteria. You have to be loyal, you have to be patriotic. That is the criteria rather than competence to run public office, which is sad in a way when Hong Kong has always been a merit-based society. And the result of that is we end up with a compliant legislature. This is sad in a way, but in a way there is nothing unusual about a repressive regime. The interesting thing is, what's the role of the judiciary in this development? When judiciary used to be the most trusted institution in the territory, but then it seems to have lost public confidence within a short span of time. And significant people now hold the view the rule of law is that judicial independence is no longer there. And is this the case, and how does it come about? I'm just worried, am I overrunning, Andrew? Thank you. Now, and just to recap, of course, the power of interpretation of the NSL rests with the MPC Standing Committee, and it prevails over all local law, but the relationship with the basic law, which is the Constitution of Hong Kong, is still unclear. But the court seems to take the position that because it is a national law, therefore it is not for Hong Kong court to challenge the constitutionality of the criminal offences there. And interestingly, it does have two clauses which provide for the protection of fundamental rights and the presumption of innocence. Article 4 and 5 are there in the National Security Ordinance law. But these articles are almost dead letter in the last few years. There were lip service referring to them, but it doesn't really have any general impact. Contrary to similar provisions in the basic law, which has generated in 2 decades a large number of liberal decisions. And judicial independence, in a wider context, of course, they tend to endure in a system where there's separation of powers and a liberal democracy. And in Hong Kong, neither conditions exist. And in politically challenging time, whether the challenge is a real challenge, a real emergency, a real crisis, or a perceived crisis, it will result in a tension between the court and the executive government. Usually the governments work by introducing or revitalizing draconian emergency law or national security law, which is backed up by ruthless enforcement by the executive. The abusive democratic changes by changing the constitutional setup, arrest of dissent, and suppression of the media. And some of these sounds familiar happen in Hong Kong as well. And for a long time, it was thought that in authoritarian regime, judiciary, independence of judiciary is just a luxury, and there's no point talking about independence of judiciary. In the last decade or so, more academic work has been doing in this regard, and finding that the relationship between the judiciary and the government, even in an authoritarian regime, is more sophisticated than expected. And of course, ruthless governments can remove the judiciary if it is not compliant. Happens in Malaysia in 1989 when the Lord Chief Justice was too active. The Prime Minister simply removed him, and he challenged the decisions in his own court, and all the way go to the Supreme Court. The Supreme Court agreed with him, set aside the removal. The next thing, the Prime Minister removed the remaining 6 judges on the Supreme Court then. It leads to a constitutional crisis. But it has also international setback when you reach that positions. So most governments do not want that kind of drastic decisions. They want the judiciary, and the judiciary has an image of independence, so that it is easier if their action was supported and endorsed by the court. It makes it easier to diffuse pressure, both domestical and international. But it also, as a result, gives the court some leeway to work, even in an authoritarian regime. And the government could restrict the judiciary by direct interference, replacing judges, packing the court with ideologically sympathetic judges, restricting the court's jurisdictions, imposing unusual process or procedure. It can indirectly interfere with the process by threatening its resources, tampering with the judicial appointment procedure, or name and shame individual judges to put pressure on that. And the more subtle thing is to re-educate the judges, bring them in line, internalize the values that the executive governments want, appeal to their sense of patriotism. And it seems all of this happens in Hong Kong in the last couple of years. And the judiciary, again, responds from what I call, it could be a responsive judicial review or abusive judicial review. Responsive in the sense that the judiciary can declare the law or its executive act unconstitutional or unlawful. But usually that will bring the court and the executive government in direct confrontation. Or the court can read down the law to mitigate its harshness or find alternative way to uphold fundamental values without upsetting the structure. This requires creativity and innovation on the court and in common law system from the lawyers as well. Or the court could just avoid the issues and hoping that the issue will go away, or someone else will address the issues, hopefully in the political arena. Or they try to adopt a conciliatory approach, buy time and space, so that by giving up some controversial case, it gives the judiciary more space in the so-called non-controversial case. The difficulty is what amounts to controversial and non-controversial is perceived by the government, not by the judiciary. And the more abusive one will be excessive deference to the government, positively legitimizing the draconian regime, or even actively suppressing democratic values and fundamental rights and become part of the repressive regimes. And varying degree, and this is not all or nothing, you can see all of this happening at the same time in Hong Kong. And among other things, one of the things introduced by the national security law is the designated judge system. Only designated judges could try national security cases, and there were blatant interference with the judiciary, in one case concerning admissions of overseas lawyers. And designated judges is designated by the chief executive. The suggestion is that it will foster expertise. But on the other hand, how much the chief executive knew about the expertise of the judges. If it is foster expertise, the matter could be decided by the chief justice, not the chief executive. So the only role the chief executive would add is to exercise political scrutiny of the judges. The designation is for 1 year, and then The tricky part is what happens if after 1 year you are no longer designated as a designated judge. Would that mean some kind of censure? The government is not happy with you. So it becomes an indirect censure. For judges at the higher court or above, probably it won't matter too much to them. But then for the judges at the lower court, particularly at the magistrate court level, where they deal with this kind of criminal prosecution all the time, these people are still early in their judicial career. They are looking for promotion. So if a de-designation, would that have some impact on their career? That remains unknown. No satisfactory explanation has been made or given why. It has to be made, or decision has been made by the chief executive. And another case, Jimmy Lai, the major case in Hong Kong, the proprietor of Apple Daily, the newspaper, he tried to secure the representation of an eminent London criminal silk to represent him in court. And London Silk is allowed to take cases in Hong Kong, represent clients on a case-by-case basis. It has to be approved by the court on the ground. The test is whether such admission is in the public interest. And many London Silk have appeared in Hong Kong, especially in the early days of the Basic Law, to bring in their expertise of constitutional litigations. And Tim Owen was admitted by the High Court. The government's appeal was rejected. The admission was upheld by the Court of Appeal and then by the Court of Final Appeal. And then the National NPCSC decide that this is a matter of national security. This is not for the court to decide. The chief executive has to issue a certificate. The court has to ask for a certificate to ensure that the matter will not involve national security before the matter can proceed. And then subsequently it leads to the amendment of the Legal Practitioners Ordinance, so that the matter now is no longer within the court discretion. When in the past this is an open process where parties could argue, the court will have to give reason whether it is in the public interest to allow such admissions. Now it is decided all behind closed door by the chief executive. And Tim Owen not only was he not allowed to represent Jimmy Lai in the litigation, he was not even allowed to come for a lecture in Hong Kong at my university. And at the last minute, he was said he gave a public lecture, and at the last minute the lecture was cancelled, and it was so embarrassing for everyone. And my colleagues, the dean of the faculty, explained that the reason for cancellation is because the dean is out of town and he cannot chair a public lecture. I've never heard that is the reason for cancelling a public lecture. I'm sure there are plenty of colleagues who are willing to chair. But the explanation is so ridiculous that everyone knows what exactly is the real reason behind. And sadly, the record of the court has not been very encouraging in the last few years. There was significant deference to the government's the low level of scrutiny of sweeping law and the readiness of the court, particularly at the Court of Appeal level, readiness to converge with mainland law and values. And indeed, it started earlier than that. In 2006, when the two legislators, the oath case that I mentioned, the two legislators who take the oath in insulting ways, and the NPC Standing Committee make an interpretation before the judgment. So the court was left with a difficult situation. Now the NPCSC has spoken. He has the case, he has to decide. And the judge quite rightly say that I will decide the case according to Hong Kong law, although he come to the same conclusion as the NPC Standing Committee. He expressly say that in my reasoning, I have ignored the NPC Standing Committee's interpretation. There's no reason to doubt the sincerity of the judge. He may come to the same conclusion, but at least he tried to preserve the integrity of the judiciary. You cannot intervene or interfere or influence by the National People's Congress halfway between the litigation, especially after he have heard all the arguments and he's at the stage of writing his judgment. So that's the best way to preserve the integrity of judicial independence. And on appeal, his decision was upheld by the Court of Appeal. The Court of Appeal could easily go along with the judge and say that I agree with your reasoning, I agree with your way of interpreting the local law. We don't need to look at the MPCSC interpretation. The Court of Appeal go all the way to say that, well, the MPCSC interpretation is binding on us. We have to rest our decisions on that. So it go all the way to embrace the MPCSC interpretation as a ground for the decisions. Then it gives rise to another problem then. The MPCSC interpretation was made after the oath has been taken. So would it have retrospective effect then? And the Court of Appeal say that, well, these are nonsense. These are common law idea of retrospective effect. We are dealing with Chinese law, and we common law lawyers know nothing about Chinese law. We cannot challenge that. We are not prepared to entertain an arguments like that. That seems to go too far to defer to China and simply reject the idea that it amounts to retrospective operation of the interpretation. So obviously, whether this interpretation would have retrospective effect and could apply to this particular case is a question of great legal importance. And it is certainly arguable because even within China, such an interpretation has been criticized, and there are arguments that it may not have retrospective effect. So the question, when it goes to the Court of Final Appeal, the Court of Final Appeal simply reject it, and on the basis, well, this is a well-settled matter, there's no question of law of great general and public importance, so they refuse to grant leave to appeal. So in a way, reflect what is said earlier, avoid the issues, let someone else resolve it, we don't want to touch it. They cannot do that. After NSL came into effect, one of the first case is the bail applications. When people apply for bail, Article 42 of the NSL said no bail shall be granted unless the judge has sufficient ground for believing that the defendant will not continue to commit acts endangering national security. It is framed in double negative. And there are the two other articles, 4 and 5, which preserve presumption of innocence and fundamental rights. When it goes to the Court of First Instance, the High Court look at the three provisions together and say that, well, the net effect, and taking everything together, the net effect is simply make likelihood of committing national security offense while on bail is a mandatory factor the court must consider. But nothing more than that. We will consider that, and then we make the decisions based on a whole range of other factors usual to bail consideration. And the court goes even so far to say that the practical application is unlikely to result in any different outcome of a bail application in the vast majority of cases as in the past. And this Article 42 should not be read as imposing a presumption against bail. This is a quite enlightening judgment, trying to read the NSL with the fundamental rights together. The decision was reversed by the Court of Appeal, by the Court of Final Appeal, in a subsequent case involving also Jimmy Lai. And the court said that, no, that is the wrong approach. We have to seek convergence, compatibility, and complementarity, whatever that means. It seems that you have to comply, basically, with NSL. And the court said that as a matter of interpretation, the only conclusion you can reach is Article 42 reverse the common law presumption of bail. And it imposed a high threshold for granting bail. And the court advocates decide that there's a two-stage approach. In the first stage, unless sufficient reason, the court has got sufficient reason to believe the defendant will not commit any national security offense, bail will be denied. You don't need to consider any other things. Only after you pass through the first stage, then other factors like the likelihood of absconding bail, the strength of prosecution witness, evidence, and so on, these would come into the picture only at the second stage. So you change the bail's consideration. The first and prime consideration is the likelihood of committing any further national security offense while on bail. The difficulty, of course, is it's framed in a negative form. You require the court to be satisfied of a negative state of affairs, which is extremely difficult. It is easy to prove that you are likely to do something by what you said, by what you do. But to prove that you will not do something in the future, this is extremely difficult to prove that. And if the burden, the court has to satisfy in the burden, it's very difficult to satisfy that high threshold. And it also bring in questions, why should other factors be excluded in the first stage? So if the case has flimsy evidence at all, why should the court not grant bail in that situation? Whereas you are now allowed, you basically ask the court, because this person is likely to commit some future national security crime, he will be detained even when the present charge is extremely flimsy. So it allows discretion, arbitrary police action of prosecutions, especially when the police adopt a very vague and all-embracing interpretation of vague NSL charges. The aftermath of that is over 80% of the cases the defendant did not get bail, and as mentioned, is some result in rather lengthy pre-trial detention, 2 to 3 years. And the application of the test is rather haphazard. How could the court satisfy that you will not commit further offense while you are on bail? So one legislator who was invited by the Foreign Consulate General to a lunch meeting, he did not reply. And the court said that, well, it doesn't matter you don't reply. The fact that you receive an invitation means you are influential. You are in a position to influence foreign consulate, and that is sufficient that you fail to establish that you will not commit further national security crimes. So it's a haphazard development and application of the law. And now the law is so vague that even T-shirts in marathon with a slogan of Hong Kong add oil, that is regarded as seditious, and no one would be allowed to wear a T-shirt of that kind. I'll skip some of these slides. It has been extended to non-national NSL charges, which is regarded to have a national security nature. Jury trial, under the national security law, the Secretary for Justice can issue a certificate and direct a trial without jury on the grounds of protection of national secrets, involvement of foreign elements, and protection of juries and the family. So far, the only ground invoked is protection of juries and the family, and up to now, no single case of national security case were tried with jury. And the Court of Appeal readily accept that, and the Court of Appeal accept the certificate on face value. There's nothing to prevent the court to ask the Secretary for Justice, if you think that the jury is in need of protection, what exactly is the base of that belief? One would have thought that when you're dealing with triad, a drug addict, the safety to jury is far more imminent than someone committing a national security crime. And why existing measure to protect jury would not be sufficient. None of these questions were asked, and the court simply accept a certificate on face values. This is the first case under national security law. The defendant, what he has done is he ride on a bike with a flag saying liberation of Hong Kong, revolution of the times. And he just run through in Hong Kong, driving the motorbike like that. And eventually when he was stopped, when police tried to stop him, he tried to avoid the police, and then he swerved, he fell on the ground, and he hit some police officer, so injured some police officer, and he was charged with an offense of incitement to secession and terrorist act. And the whole case turns on the meaning of the phrase liberate Hong Kong, revolution of our times, and both sides call expert evidence. And I was at a loss, why do you need expert? If you are charged with inciting the public, of course what is relevant is how the public is going to read it, not how the expert is going to read it. If you make an incitement which only expert can understand it, now how could you incite anyone? And frankly, if you ask me to kill someone, at least if I carry that action, that would be a murder crime. That's what incitement is about. The incitement, if it were carried out, it would commit to a crime. But liberate Hong Kong, revolution of our time, I have absolutely no idea what it asked me to do. And how could anyone be incited without knowing what you are actually asked to do? But nonetheless, he was convicted on that ground. And as far as terrorists is concerned, the court found that challenging to the police instill a sense of fears among law-abiding members of community that could lead to a breakdown of law and order, and therefore, this is a terrorist act. This is far-fetched from what ordinary people understand what terrorist means. And for that, he was sentenced to 9 years imprisonment. He's still serving his sentence. The The next case, this is Captain America. As you can see why he's called Captain America. What he did is just distributing some leaflet and chanting some slogan. And unlike the first case, at least you can say that it involves some violence. And the court said riding a motorbike is a violent act. Whereas here, he did nothing except chanting some slogan on the street. And again, he was charged with incitement to secession, initially 5 years and 9 months imprisonment, reduced to 5 years. He was the one who lost the remission simply because he got 2 more days to serve after the new law has come into effect. And archaic criminal law and notably seditious publications were reintroduced, which have not been used for almost 50 years. And the Court of Appeal not only in upholding that, and the common law either have repealed the offense or require that for seditious publications, at least you have to have an element to incite violence or to incite public disorder. And the court basically say the overseas jurisprudence are irrelevant because of the unique circumstances of Hong Kong, without explaining in what way is it unique. And when the parties cite Saracusa principles, which is well accepted internationally, the court say that this is outdated and reject that. And the defendant was appeal was rejected, and he got leave to appeal to the Court of Final Appeal. So this case will be pending before the Court of Final Appeal. So up to this point, it disappoints everyone. This is a rather gloomy situation. Not everything has lost. There's still a few cases which is encouraging. In one case, the governments apply for an injunction of broadcasting a song called Glory to Hong Kong. That was a song composed during the 2019 civil unrest. It's a very nice song, actually. And the song was so popular that it was mistaken to be the national anthem of Hong Kong or China. And in a number of major sporting events, when Hong Kong people got the champions, this song was broadcast, which put the government in a terribly embarrassing position. So the government now wants, and part of the reason is some of the people said that we just go to internet and search for the song, and this song happens to be most widely broadcasted, or we thought that is the national anthem for Hong Kong. So the government wants to seek an injunction, primarily actually with Google and some of these major giant tech in mind. But they apply for an injunction and restricting the broadcast of these songs. And not known to the public, the chief executive actually issued a certificate saying that broadcasting of this song is a matter of national security. And that is binding. That certificate was not known until it was reviewed in the judgment. But interesting, the court said that by all means, I accept that it is binding on me. This is a matter of national security. But this is not what I'm asked to decide. I'm asked to decide what to do with it. And whether I should grant an injunction or not, that is my jurisdiction, not the CE. And the court asked, is there any utility or necessity of granting an injunction, given that if you can prove that there's a breach of the court order, you'll be able to prove a serious national security offense already. And the court said that if the target act is lightly penalized, why should the civil court impose an injunction which could attract more severe penalty when Parliament consider unnecessary to do so? But if it is heavily penalized, as it is under the national security law, what purpose will the civil injunction add to the criminal law? And is it right for a civil court to pass judgment without procedural safeguard in criminal law for an effectively serious crime? And on that basis, the court found there's no utility, there's no way you can enforce it. And if the criminal law is not sufficiently deterrent, what does it add for a civil injunction order? And the court refused to grant the injunction order. The matter is now on appeal to the Court of Appeal. And there are other cases, which I won't go into details. Yeah, I'll bring it to an end, except that just one or two words, and this is not even the end. As if the national security law is not bad enough, the government passed another safeguarding national security ordinance just a month ago, and it tightened up existing law, including treason, insurrection, theft of state secrets, sabotage, national security, and external interference. And the few comments quickly I can make, it enlarged the scope of existing law, introducing sweeping scope of law, including codification of archaic common law offense of seditious publication. It substantially increased in sentence of all existing offenses relating to national security law, and it wholesale adopted concepts on the mainland, including what amounts to national security, what amounts to state secrets, and it stifle any investigative journalism on whistleblowing, and as a result, any criticism of the government becomes a high-risk activities. Just skip a few more slides. National security is a highly wide concept under mainland law, and national secrets, or state secrets, now include social economic development, major policy decisions, economic social developments of a country. Almost anything you can imagine is now national secrets or state secrets. And not only you disclose, and state secret has been used or abused in a very significant manner over the mainland. On the mainland, almost anything could be state secret. And it seems that we are now adopting similar definitions. And not only that, it also targets at public officers or government contractors, that if you disclose something which is a state secret, then of course it's a criminal offense. But if you disclose something which looks like a state secret, and it turns out not to be state secret, still a criminal offense. Now, this is interesting and beyond logic. Why would you disclose something which is not state secret be a criminal offense? But apparently this is targeted at whistleblower and make investigative journalism extremely difficult. And journalists receive so-called leakage from government officials all the time. Leakage is one standard way of government testing the water, and then they can later deny that they leak. And what could the press do with allegedly leakage documents from the government, which they could later say that it is not authorized, and so on? And the Journalists Association expressed grave concern. And external influence, it could collaborate with an external force, and external force is widely defined, and using improper means could include material misrepresentation. And in recent years, whenever Hong Kong is being criticized, Hong Kong said that this is blackmail, this is misrepresentation. So virtually anything the government deny could become misrepresentation. And to bring an interference effect, so anything which try to interfere with the legislative process, judicial process, etc., so which could cover any kind of lobbying efforts when you're lobbying the legislature, and as long as you work with an overseas organizations, you are in a high-risk territory, and all these have extraterritorial effect.
Get back
Yeah.
to that during the Q&A session.
Yeah. So I'm ending that now. So what brings us is now Hong Kong comes to a very different situation. I hope the quick overview gives you a sense of what's going on in Hong Kong. Will it be the end of judicial independence? This is probably still early to say so, because most of the decisions are still at the lower court. The Court of Final Appeal has not been tested. It has not been easy. But for anyone who works on human rights or constitutional matters, you can only hold your faith and never say never. And probably that brings me to the end. Sorry about that.
Thank you so much, Johannes, for this extremely interesting talk you gave us. Maybe it was a bit naive from our side, right, to invite somebody like you who knows that much about this to review this, the whole development of the past 25 years or so in a couple of minutes. So that was so interesting. Thank you very much for coming and sharing all those thoughts and developments with us. Now, if you had some questions, we would be happy to extend a little bit the stay we have here in this room. I hope they don't kick us out. And then you are free to ask. Maybe a first question from my side. If you think back, could all that have been prevented from happening, at the beginning when the handover took place and you had this 50 years of secured common law, separate common law legal system, which is now in bad shape probably. Could this development have been prevented? Did somebody do something wrong? Could somebody have acted more wisely?
I think so. It is a series of mismanagement of the crisis in a way. Although to some extent China did play a part, as I said, that right from the beginning they are thinking of one country, two system, and one country, two economic system. But at least they exercise a significant degree of self-restraint for the first 10 years and so on. And for the triggering effect, one is the Occupy Central umbrella movement in 2014, and then the civil Anti-Extradition Act in 2019. And both events could have been prevented. And sadly, it's my colleagues in the faculty, Benny Tai is heavily involved in Occupy Central. He's the instigator. And he has been advocating that civil disobedience for years before he actually implemented. And even when he implemented, I was at the height of, well, before he started, and I ran into the Secretary for Constitutional Affairs and asked him that, you know about all these Occupy Central things coming and so on. Would it be sensible for you to talk to Benny and see if there's any way we can resolve the issues, well, without going all the way? And asked, have you ever talked to him? And he said, no. I said, you have been learning about it at least for a year or so. And as any responsible government, I think they would try to reach out and at least try to see if these matters could be resolved. And you just let it escalate and so on. And then after 2014, when the umbrella movement was brought to an end by court injunction, actually it was followed by a period of relatively peaceful things. And if the government is genuine and try to resolve the democratic dispute, probably what would have happened later would not have happened. And even for the two legislators who is a bit naughty and try to take the oath in a rather insulting way, the president of LegCo actually asked them, why don't you do it again? I give you another chance, you do it again. And then the Secretary for Justice say, no, once you have failed to do it, you are disqualified forthwith. So the interesting part of that litigation is that the applicant is the Secretary for Justice, the respondent is the President of the Legislative Council. So it's totally unnecessary in a way, and these things, if not for mismanagement, it would not escalate. And later when the oath is used in a weaponization way, trying to disqualify all peoples, again, it is going all the way. And then when we come to the extradition treaties, it's quite clear from the beginning, it is not about Taiwan and Hong Kong, it is really about mainland China. And when 1 million people go on to the street, 2 million people went to the street, any sensible governments will at least put it on hold and try to look at it. And especially when the opposition comes not only from the Democratic Party, it comes from a lot of businessmen who have first-hand experience on mainland China. They don't want this kind of extradition arrangement. So, and the chief executive insists to go ahead, which end up in rather violent confrontations at the end. And I think the rest is history. So I think there are quite a number of occasions where a more sophisticated government could have avoided this problem. And of course, looking from hindsight, it is always possible to resolve this issue. But even at that time, a lot of people say that this matter could have been resolved if the government is prepared to take some steps, or some steps, try to draw a compromise and so on.
And is this a coincidence that also in China the leadership had changed some 10, 12 years ago?
Right. Yes, as I said, it's in 1984, China needs Hong Kong more than Hong Kong needs China. But when it comes to 2010, 2013, China becomes a major political, economic superpower. Xi Jinping also came to power. And at that time, at the early days, there were a lot of self-restraint. And one thing which I remember quite clearly is in the early days when I visited Beijing, the government ministers, academics, they all say, well, Hong Kong is a very sophisticated system. It is very advanced. We don't know how to run it. We have to learn from Hong Kong. By 2013, when you met Chinese officials, they said, we can run Shanghai, we can run Shenzhen. What's the deal with Hong Kong? We can run it. So the kind of patience, the kind of tolerance, the kind of self-restraint has gone, coupled with the economic success. So that to some extent also contributes to how the matter was escalated.
Are there questions from the floor, please? Microphone, please.
Is it realistic that Hong Kong could ever return to liberalism, or at least get parts of it back?
I would love to see that. And I think it has reached a point that it is very difficult to go back to what it is. It has gone too far by now. And when civil society is gone, a lot of people, and even just in the last 2 years, at least 200,000 people have left Hong Kong to UK, let alone also Canada, Australia, are popular places. And indeed, Hong Kong suffer because it is not just the rich people who leaves. Most of the rich people stay there because they can leave any time. But it is really the middle class, the professional, the experienced administrators. And recently we have seen one maladministration after another, and all sort of silly things that the government has been doing. It's because of lack of experienced people. A lot of experienced people have now left. And once they leave and settle in a foreign country, it is very difficult for them to go back now. One difference in 1990s, indeed after the Tiananmen event in 1989, there was also a wave of immigrants. A lot of Hong Kong people leave for US, Canada, UK, Australia. But at that time, most people leave because they want to get an insurance policy, get a foreign passport, and then they can come back to Hong Kong. So they leave because of the uncertainty of what will happen in 1997. This time, people leave for the certainty. They feel that what is certain to come. And when they leave, in the past, in the early 1990s, typical example, the family leaves, they fulfill the residential requirement, the mother and the child may be staying overseas, the husband goes back to Hong Kong and work. These days, we see the departure is the entire family. Sometimes even the elder generation is moving. So people are really uprooting themselves, and which makes it far more difficult for people to return. It is replaced by a group of people, and Hong Kong is still claiming that it has attracted a lot of international visitors. But when you look at the figure, 75% of that international visitors comes from mainland. And the government may be thinking that they can replace Hong Kong with talents in China. There's no doubt that there are a lot of talents in China, but a lot of them may see Hong Kong just as a stepping stone. You don't have that kind of local commitment to the local environment and so on. So it would be a very different Hong Kong. I won't say that it will never get back, but at least in the short future, it is difficult to see how Hong Kong can come back. And it is also the international capital is moving. A lot of international organizations are now resettling themselves. And again, Singapore is probably the major beneficiary in all these. Quite a number of them have moved to Singapore now. And once they move their headquarters, it will not be easy for them to come back. And the former a major economic analyst, and recently did an interview, and he suggests that the major difficulty Hong Kong face is that in the past, Hong Kong can stay outside international dispute, particularly between US and China. Now it tries to take side, and once you take side, you become a victim of this geopolitics there, and you can't get out. And the other thing is Hong Kong now rely too much on China. So if China's economy is going down, there's no way Hong Kong can keep its economic development. And all this will have a rippling effect. So at least in the short foreseeable future, I don't see it is realistic that Hong Kong could come back. In the longer term, it is difficult. And people who leave now, they are not necessarily politically sensitive or vulnerable person. A lot of people leave because they don't want to see their children being educated when even in kindergarten you have to learn about national security and all those things. They don't want that kind of indoctrination. And once you touch the education system, it touched the nerve a lot of parents. And parents are prepared to do anything to avoid that from happening. So it's a very sad assessment.
There is another hand there, please.
Thank you very much for the insights that you've provided. You've raised a question in my mind whether this is totally new in the sense of the domestic Chinese legal system, or is this simply a duplication of what already existed within China?
This is probably both, and some of the technique that China has been using, for example, the large number of reporting. They set up that hotline and encourage a large number of reporting. We've seen that in Cultural Revolution, typical, asking people to keep surveillance on other people. So everyone will become an enemy. You cannot trust anyone. And some of these are the entrenched in the socialist system, and this is basically concentration of power. They don't believe in sharing of power, let alone judiciary. And judiciary for them is you can be independent as long as you do not stand in the way of national policy, you do not obstruct government's policy, then you could have independence. So all these are reflected gradually, and now we are gradually implementing the Chinese system into Hong Kong. So this is not entirely new in a way. What is surprising to a lot of people is it comes so quickly and so fast, and notwithstanding in the last 2 decades, things are still going right, and suddenly in a few years' time, things could change and so change so quickly. And even one thing which we're still working on is how would the judges change so quickly? They're still the same judges. And before 1990s, before 2012, we praised the court. The court is the most trusted institution. Now some of the judges seems to go the other way around. Partly they were disturbed by the social unrest in 2019. And in one case, dealing with the invocation of emergency law, the government passed an emergency law just shortly before COVID that everyone will not be allowed to wear a mask in public demonstration, even if it is peaceful and lawful and authorized. And I was the counsel representing 26 legislators to challenge the law. And one of the things in the discourse is when we argue whether this is proportionate and so on, the police provide evidence, even at the worst period of the 3 months of social unrest, there were about 130 public demonstrations which was authorized by the police. Among them, only less than 30 end up with violence. So the large majority, over 70% of the demonstration at that period of time was still lawfully carried and peacefully carried out. And one of the points I asked the court, look at this, and do you impose a kind of restrictions and requiring people to lift their masks could be a kind of restriction. People have all kinds of reasons not to expose themselves in public demonstration, legitimate reasons. And if 70% ends up in peaceful and orderly manner, is that sufficient justification to impose